"Sir, you need to take that off before you come any further." The bailiff said it the way people say things in courtrooms, with the flat, practiced authority of institutional routine. The voice of a man who has said the same sentence 400 times and expects the same result each time, which is compliance. Because the courtroom is one of the last places in American civic life where compliance is still an ambient condition of the room rather than a negotiated outcome. Dale Pruitt was 44 years old, 20 years on the job, built with the particular solid density of a man who has spent 2 decades standing in doorways. And he was standing in the doorway between the anteroom and courtroom 7 of the Harmon County Civil Court on a Wednesday morning in October, with his hand extended in the direction of the old man's jacket. The old man was 80 years old. His name was Leonard Crow, and he had been sitting in the anteroom for the better part of 2 hours, waiting for the morning civil docket to reach his case. A property dispute involving a parcel of land in the eastern part of Harmon County that his family had owned since 1958, and that a development company had spent the better part of 18 months attempting to acquire through mechanisms that Leonard's attorney had described, in a voice carefully stripped of editorializing, as aggressive. Leonard had arrived at the courthouse at 7:45 in the morning, which was 45 minutes before the clerk's office opened, because Leonard Crow had a lifelong difficulty with the concept of arriving at things late that had its origins in a period of his life he did not discuss at length, but which had produced in him, among other things, an absolute intolerance for tardiness in himself, if not in others. He was wearing dark trousers and a plain white shirt with a collar button fastened, and over it a jacket, canvas, dark green. The kind of jacket that had absorbed so many seasons of Georgia weather that it had ceased to be waterproof in any technical sense, and had instead achieved something beyond waterproofing, a kind of fundamental accord with moisture that meant it was simply part of the jacket now, indistinguishable from the fabric itself. The jacket was not military in any official designation. It was a civilian garment. But on the inside of the left forearm, visible when the sleeve rode up, which it did, because Leonard Crow had bought this jacket in 1987, and his arms had not changed, but the jacket had shrunk through years of washing. There was a tattoo. Not on the outside of the arm where tattoos are displayed, on the inside, where they are kept. This was relevant information that Dale Pruitt did not yet possess. What Pruitt did possess was a standing courtroom protocol, established by the presiding judge, that prohibited outerwear in the courtroom during proceedings. A policy implemented after an incident 18 months prior involving a man who had concealed a recording device in a jacket lining, and had produced a secondary litigation headache that the court was still managing. The policy applied to all outerwear. Dale Pruitt applied policies to all people equally, which he understood to be fairness, and which was fairness in the limited technical sense that fairness becomes when it is divorced from context. "It's just a jacket," Leonard said. His voice was low and careful, a dry, even register, the voice of a man who measures what he says, not because he is uncertain, but because he understands that precision is more useful than volume. "Policy, sir, all outerwear comes off before entering the courtroom. You can leave it on the hook there." Pruitt indicated the row of hooks inside the anteroom door with a nod. Leonard looked at the hooks. He looked at the jacket. He had been wearing this jacket in courtrooms and waiting rooms and government offices for 37 years, and he had never before been asked to remove it. But then there had not always been a policy, and this was a different courthouse. And he was not the kind of man who makes his preferences the centerpiece of other people's days. He reached up and began to unbutton the jacket with his right hand. His left hand, the one with the inside forearm tattoo, was carrying his manila folder of documents, which he transferred to his right as he worked the buttons. The sleeve of his shirt rode up as he shifted the folder. and the tattoo became visible. Dale Pruitt was not looking at Leonard Crow's forearm. He was looking at the door to courtroom 7, managing the flow of the morning's docket, and he did not see it. But a young woman seated against the wall of the anteroom did. Her name was Claire Beaumont, 26 years old, a second-year law clerk for the Harmon County Civil Court, present in the anteroom that morning because she had been tasked with managing the docket flow and ensuring that each case's parties and attorneys were present and prepared to enter in sequence. She was reviewing her clipboard with the focused attention of someone for whom the morning represented a logistical exercise requiring her full concentration, and she looked up at precisely the moment that Leonard Crow's sleeve rode up and the inside of his forearm became visible. She had grown up in a military family. Her father was a retired Army warrant officer. Her uncle had served in naval special warfare. She had spent her childhood at the specific intersection of military culture and American history that produces, in some people, a deep and automatic literacy for the markers and symbols of service. She was not an expert, but she knew enough. She looked at the tattoo on the inside of Leonard Crow's forearm, the specific image, the specific configuration, the unit designation rendered in ink that had blurred slightly at the edges with age but remained legible in its essential form. And she went very still. She looked at the man, 80 years old, canvas jacket, manila folder, property dispute. She did the arithmetic of the morning with the rapid, intuitive calculation of someone who understands that information exists in combinations and that some combinations require immediate action. She excused herself from the anteroom with a quiet word to the deputy clerk and walked quickly down the corridor to the chambers of the Honorable James Whitfield, presiding judge of the Harmon County Civil Court, who was at that moment reviewing the morning's docket with the concentrated unhappiness of a man who has discovered a scheduling conflict and is determining which of the two conflicting parties is going to be disappointed. She knocked. "Come." She entered. She said, "Judge Whitfield, I'm sorry to interrupt. There's something you need to know about the Crow property case." Whitfield was 61 years old, 23 years on the bench, a man whose judicial temperament had been shaped by 2 decades of watching the distance between what people thought was happening and what was actually happening. A distance that was, in his experience, almost always larger than either party expected. He was not a patient man in his private life, but had developed, through necessity, the functional patience of someone who understands that rushing toward conclusions is a form of professional negligence. He looked at Claire Beaumont over the rim of his glasses. "Tell me," he said. She told him. She described the tattoo. She described its location, the inside of the forearm, not displayed but kept. She described the specific insignia as best she could, the unit designation she had recognized from a photograph in her father's study that had hung there her entire childhood, above a caption that her father had never needed to explain, because the image itself explained everything it needed to explain about the men who had earned the right to put it on their bodies. Whitfield listened. He did not move while she spoke. When she finished, he took off his glasses and set them on the desk, and sat for a moment looking at the surface of his desk, the way people look at surfaces when they are organizing something interior. He put his glasses back on. He stood up. "I'll be in the courtroom in 5 minutes," he said. "Make sure Mr. Crow is seated." She went back to the anteroom. Leonard had removed his jacket and hung it on the hook and was standing with his manila folder and his patience intact, which was a thing Leonard Crow had in considerable reserve. She told him the courtroom was ready and escorted him in and seated him at the plaintiff's table and went to her position at the side of the room. The courtroom for a civil docket at this hour was not full. The parties in the Crow property case occupied one table each. Leonard with his attorney, a quiet and methodical man named Gerald Fitch. On one side, the development company's two attorney team on the other. Several other parties waited in the gallery for their own cases. A court reporter sat at her machine with the posture of someone prepared to transcribe whatever the morning produces without editorial comment. The air smelled of floor polish and stale coffee, and the particular institutional stillness of a room that has heard a great many arguments and resolved some of them. Whitfield entered. Everyone rose. Everyone sat. He looked at Leonard Crow from the bench, a direct, assessing look. The look of a judge evaluating a case before him, but also something else underneath it. Something that was not quite judicial and was not quite personal, but lived in the space between. The look of a man locating something he was not expecting in the morning's docket. He said, "Before we proceed, Mr. Crow, I understand you were asked to leave your jacket in the anteroom." Leonard looked up. "Yes, Your Honor. I'm going to ask you to retrieve it." A brief silence. Gerald Fitch, Leonard's attorney, looked at his client. The development company's lead attorney, a man named Harrington, who had argued 43 cases before Whitfield and felt that he understood the judge's temperament with some precision, looked at the bench with an expression of carefully managed puzzlement. Leonard rose, at the pace his body required of him, and walked back to the anteroom, and returned with a canvas jacket, and sat back down with it folded across the arm of his chair. "Put it on," Whitfield said. Leonard looked at him. The winter-gray steadiness of his eyes, pale and clear and carrying in them the depth of a man who has been patient with the world for a very long time, met the judge's gaze across the courtroom without flinching and without performing. He put the jacket on. "Mr. Crow," Whitfield said, "I'm going to ask you a direct question, and I'd appreciate a direct answer. Were you ever assigned to Military Assistance Command Vietnam Studies and Observations Group?" The courtroom went very quiet. The court reporter's fingers rested above her keys. Harrington's co-counsel leaned slightly toward him. Gerald Fitch looked at his client with the expression of a man discovering that he did not have complete information about his own case. Leonard was still for a moment. "Yes, Your Honor." "What unit?" "Recon Team Illinois. Operational Detachment B-57. Command and Control Central." Whitfield nodded slowly. He was quiet for a moment, the kind of judicial quiet that is not deliberation about procedure, but deliberation about something the procedure does not have a category for. Then he said, "To the courtroom at large, to no one specifically and everyone simultaneously, for those present who may not be familiar. MACSOG was a classified special operations unit that conducted covert missions in Vietnam, Laos, and Cambodia throughout the Vietnam War. It was among the most dangerous assignments in the American military during that conflict. The casualty rate for recon team members ran in some periods above 100%, meaning teams were replaced entirely more than once. The men who served in it were not discussed publicly for decades, and many of their operations remain classified. The tattoo Mr. Crow carries on his left forearm is the unit tattoo of Command and Control Central." He paused. "There are not very many people left alive who have it." Harrington cleared his throat. It was the throat clearing of a man who has spent his career in courtrooms and understands when the architecture of a proceeding has shifted in a way that is not favorable to his position. "We will proceed with the case," Whitfield said. "But I want it on the record that this court is aware of who is sitting at the plaintiff's table, and that this court takes seriously the obligation, which is not a legal obligation, but a human one, to ensure that proceedings before it are conducted with full respect for the parties who appear." All parties. His eyes moved briefly to the defense table and back. Proceed. Mr. Fitch, the case was heard. It lasted 2 hours and 40 minutes, and every moment of it was conducted with the specific seriousness that falls over rooms when the room has been reminded that the people in it are not abstractions. Whitfield asked precise questions. He allowed Fitch to develop Leonard's argument fully and without interruption. When Harrington attempted a procedural objection that Whitfield found technically correct but practically obstructive, he sustained it and then rephrased his own question from the bench to achieve the same information by a different route, which was well within his authority and which he exercised without comment. He ruled from the bench at the end of the morning. He ruled in favor of Leonard Crowe on the primary property claim, citing a deficiency in the development company's chain of title documentation that Fitch had flagged in his brief, and that Whitfield found, upon examination, to be not a deficiency, but an absence. The Crowe family's ownership of the eastern Harmon County parcel was confirmed as continuous and uncontested from 1958 to the present. The development company's acquisition effort was denied on its current evidentiary basis, with instructions that it could refile if and only if the chain of title issue was resolved, which Whitfield assessed in his ruling. With the mild, dry precision of a man who has read a great many documents, as unlikely, Leonard Crowe sat at the plaintiff's table and listened to the ruling with his hands folded on his manila folder, and his expression displaying the specific quality of a man who has been patient for 18 months and is now watching patience produce its result. He did not display triumph. He had not come here for triumph. He had come here for his family's land, which was not the same thing. Gerald Fitch shook his hand. Leonard thanked him with the economy of a man who means his thanks but does not inflate them. In the corridor outside the courtroom, Whitfield caught him at the elevator. The judge was still in his robe, which he rarely wore in corridors, which meant he had come out immediately after adjournment. He stopped Leonard with a hand briefly touching his arm and said, when Leonard turned, "My father served in the 1st Cavalry in Vietnam. He came home. A lot of men he knew did not." He looked at the canvas jacket. "I want to thank you, not for today's proceeding, for your service." Leonard looked at him for a moment with those steady, winter-pale eyes. He said, "How old were you when he came home?" 4, Whitfield said. Leonard nodded. Something moved across his face that was not nostalgia and not grief, and lived in the specific register of things that are simultaneously losses and gifts, the way certain experiences are both of those things for the rest of the life that follows them. "They were good men," he said. "All of them. The ones who came home and the ones who didn't." He pressed the elevator button. "Tell your father that, if you haven't." "He died in 2019, Whitfield said. "Then you already know," Leonard said simply. The elevator opened. He stepped in with his manila folder and his canvas jacket and his family's land intact and confirmed by a court of record, and the doors closed. Whitfield stood in the corridor for a moment. The courthouse moved around him in its ordinary Wednesday morning way. Clerks with carts, attorneys with briefcases. The ordinary traffic of civic machinery processing the ordinary business of human disputes. He went back to his chambers. He sat at his desk. He looked at the docket for the afternoon, which was 4 cases, 2 of them straightforward and 2 of them not. And he thought about a 4-year-old boy whose father came home from a war that many of his friends did not, and about an 80-year-old man with a tattoo on the inside of his forearm who had spent 18 months defending a piece of land that his family had owned since 1958 and had driven to the courthouse at 7:45 in the morning because he did not believe in arriving late. 2 things that mattered. He picked up his pen and began reviewing the afternoon's briefs. There are men who carry their history on the inside, not the outside, in places that require proximity to see, that reveal themselves only when the sleeve rides up, only when the light is right, only when someone who knows how to look is looking. They do not wear their service as a credential or a shield. They wear it the way they have always worn everything, with the same quiet economy they brought to the work itself. They sit in anterooms and wait their turn and hand over their jackets when asked, and do not make their experience the problem of the room. And sometimes, because someone looks carefully enough and early enough, the room returns the favor. If you were moved by Leonard Crow's story of quiet endurance and hard-won justice, hit that like button, share this video with someone who needs to see it, and be sure to subscribe to Veterans Valor for more stories of America's unassuming heroes.